All right, welcome to lecture 2 for topic 11. And in this lecture, we're going to look at the eras of work policy. There are two main eras of work policy that your textbook takes a look at as it relates to gender. The first era is era 1, known as the protective labor laws era, for about 100 years, from the 1850s to the 1960s. And the other era, era 2, is the era of equal opportunity labor laws, starting in the 1960s, and those persist into the present. So let's get started. So, as we learned from the last lecture, how society answers the question, why do women work, provides a gateway to understanding corresponding policy. Traditionally, policy often reflects underlying assumptions that working women is somehow not normal and thus gains and demands government attention. But as gender expectations change, so do underlying assumptions and policies. So as we move into the era of equal opportunity laws, there is a huge change in gender expectations and roles. Rather than thinking that women working is somehow a problem that needs government attention, women working is seen as a step towards full equality. So let's start with the first of the two eras, the protective labor era policy. So the first major policy era is the protective labor laws. The backdrop for the protective labor laws for women is industrialization, starting in the mid 1800s, the 1850s. And so, we see a tremendous amount, not just in the United States, but elsewhere in the industrialization, the rise of factories, the rise of manufacturing, the rise of textile plants, the rise of mining, etc. And so there's a lot of industrialization that's going on. And with that industrialization comes concerns about working conditions, because working in factories can be dangerous. Working in textile manufacturing factories can be very dangerous as well. Mining, there's a lot of danger associated with that, and that if there's not, and there wasn't at this time, government regulations protecting workers, then workers could be really harmed on the job. And so, reformers and progressives in the United States were really looking at wanting to get protective labor laws for everybody. Okay. And so, in response to working conditions being horrible, and also that there were no limits on the number of hours that you could work, that these groups that were interested in a more progressive labor laws, they were fighting for protection for all workers. And there was an attempt to states at this time period began passing laws that were placing limitations on businesses, to try to make the working conditions safer for the workers. And there's a famous case, it's from 1905, and it's called Lochner v. New York. New York passed a minimum hours law, and it was for bakers, which would make sense. You're in like an industrial baking facility, you're using huge mixers and ovens and these sorts of things, and those can be pretty dangerous places, and you want your workers there to not be tired. And so if you're working 12, 15 hours a day, you're going to fall asleep and something bad could happen. Or not fall asleep, but you may not just be as attentive on the job. And so New York passed a law saying that bakers could only work a 10-hour work day. And they thought, great, progressive legislation protecting the workers. It was deemed unconstitutional by the Supreme Court of the United States. Why? Well, that the Supreme Court said that because of the due process clause, that says that you have the right to life, liberty, and property. Those things can not be taken away from you without the due process of law, some sort of orderly process. They basically said that this New York law, taking away your freedom to work more than 10 hours a day, that was a violation of the due process clause, because people had the liberty, they had the freedom to contract. And if you want to get a job and sign a contract with your employer saying, I'm going to work 10, 12, 15, 20 hours a day. Heck, I want to work all day long, right? Then you're free to do that. And so they said that that New York law violated that. They also said that it interfered with commerce and that it ran afoul to the Commerce Clause in the Constitution. And Lochner is a famous case not just for gender and protective labor laws, but it's a really famous case because it gives this really expansive understanding of liberty in the Due Process Clause. But also it shows just how predominant the viewpoint is in terms of protecting free market or laissez-faire capitalism. That was the dominant viewpoint, and laws were not going to interfere with the capitalism. Now, you might be asking yourself, what does Lochner have to do with labor laws for women? Well, after Lochner, there was a sense that uh, that that women, not all workers, but maybe just women workers, need special protected protections. And so coming out of Lochner, there was the sense of we're not going to give up when it comes to reform and progressive laws. What we're going to do is that we're going to pass laws that are protective of a particular class of people. And the particular class of people would be women and children. And so for social feminists, remember earlier in the semester, we talked about the difference between social feminists and egalitarian feminists. Egalitarian feminists were like equality for all, right? That women and men aren't fundamentally different. But remember, social feminists are saying women and men are fundamentally different, and we need to recognize these differences, and that because women are different, they deserve different protection from the law. And so they argued that women workers needed special protection. And after Lochner, and again, this is a really good example of how feminists will join with other political movements in the United States in order to achieve their goals. And so after Lochner, progressives still wanted to have protective labor laws. Social feminists also felt like they wanted protective labor laws for women. And so they joined forces. And they say, look, if all workers can't get special protection, let's focus on certain workers. Let's focus on getting special protections for women and children. You wouldn't think you'd need protective labor laws for children, but we all know that children, hey, freedom of contract, that children workers were also adversely affected by the industrialization. You might think that working in a factory as a child might be a benefit. What's the adverse effect there? But I think most of us would agree, not best. Now, you might be wondering, why do social feminists feel that women workers need to be treated specially? Why do they need special treatment as it comes to labor laws? And there are several reasons that your textbook gives for why social feminists felt that women need these special protections. One is, and it's a reflection of these traditional gender norms that we talked about in the first lecture. Women don't choose to work from the social feminist point of view, but they're forced to work due to some sort of failing, right? They're forced to work because of bad circumstances. And so the bad circumstances are that their husband died, right? And so that they don't want to work, but they're a widow and they have no other choice but to work. That they're a product of divorce, okay? And a divorce is a failure of traditional gender norms. Women would get divorces because either their husband were drunks or, not able to provide for the family, abusive, and so they divorced. Divorce was rare, it happened, and divorce was usually an indication of some sort of social failure. Another assumption or claim that the social feminists make is that work is harder on women than it is on men. Social feminists believed that there were physical differences between men and women. And there are some physical differences between men and women, just biologically, but that they basically said that women were weaker, that they could not work as many hard hours and long hours, that it had a much harder impact on their body. And because of their lack of upper body strength or other sort of fragilities of women, that it was much more dangerous for women than it was for men. So they needed protection. And then finally, they said that the damaging impact of this physical work, um, that can lead to bad health. And so, chronic fatigue, physical fatigue, that's going to lead to bad health, and not just bad health for the woman, but bad health for the future generations. Because if you are not in good health and you get pregnant, and then it's possible that your baby's not going to be healthy either. So, these were a whole host of reasons that the social feminists gave for why protective labor laws needed to be in place. So we need to these protections in place until they can get back to their proper responsibilities, because they didn't choose to work, but since they're working, they're going to get these protections. So there are three types of uh, protective labor laws that the progressives and the social feminists sought during this era of getting protective laws for women. One was that they wanted to make sure that women could only work in certain occupations. That there was a long list of occupations that women were prohibited from working in. And so they were prohibited from working in men only occupations. When you look at the list of what's considered men only occupations, you got mining, bartending, being a bellhop, meter reader, elevator operator, a smelter, which means, I think it doesn't mean that you catch the fish, the tiny fish, but that I think it has to do with iron work, working in a bowling alley, etc. You might sort of think, well, what is being like an elevator operator? Goodness gracious, why is that a men's only job? And that doesn't seem like that would be too physically taxing. But you can't have ladies coming in being in an elevator by themselves, because those men, they might take advantage. Same with meter readers. Women can't go into houses alone because who knows what might happen. So anyways, the progressives and the social feminists wanted to protect women from jobs that were dangerous. And as I just stated, that those jobs were far ranging. They're often based on stereotypes. And designed to protect women from immoral situations. Example, can't be working in a bar because, well, bars, nasty places. Just joking. So another type of protections that the progressives and social feminists sought were to protect women for certain working conditions. And so those conditions would be that protecting them from long hours. So saying that they could only work 10-hour work days, that couldn't work at night. Again, that might have to do with both the dangers associated with working at night, but also like taking you away from the duties that you have at home, and also putting limitations on how much women could lift. And then finally, women must receive a minimum wage, okay? And so they sought minimum wage laws, not for all workers, although the progressives sort of liked that, but for women workers. And you might be thinking, well, wait a second, I kind of get 1 and 2, but what's going on with 3? Well, keep in mind, it's the assumption that women are working not because they choose to, but that because they have to, because they're widowed or because they're divorced, okay? Or because their men are off fighting a war. And so that you've got to make sure that women are getting a minimum wage, because they are being a provider, and they're not supplementing their family income. They're providing for their family income. And so for that reason, they felt that women should receive a minimum wage. But I guess men, no need for that minimum wage, because I guess good men work hard and are able to provide, but whatever. Now, keep in mind that in intersectionality here, that protective labor laws excluded a lot of women, and so they are really talking about certain occupations and certain manufacturing, factoring, etc. And a lot of jobs in the South, agricultural jobs, and also domestic help jobs, mostly in the Southern, not entirely, but more prevalent in the South, were exempt from these kinds of, they weren't exempt from the laws. These laws did not apply to the agricultural and domestic sector. And so a lot of women of color in particular were left out of the era of protective labor laws because they did not apply to those sectors. So you might be thinking, in light of Lochner, that you might question and wonder, like, are these types of protective labor laws that are targeted to women as a class of workers, are those constitutional? I mean, in Lochner, they said no, those protective laws are not constitutional. That they're unconstitutional. That it interferes with a person's freedom to contract for work. And so the question is should the same reasoning extend to the special category of protective labor laws for women? And so should Lochner say, well, we didn't let bakers have 10-hour days. Why would we have women have 10-hour work days? Or will the court find that it's constitutional to treat women differently? And that comes to the court in the case Muller v. Oregon, which we'll take a look at next. Well, this question comes to the Supreme Court in the case of Muller v. Oregon, a few years after the Lochner case. And this case deals with protective labor laws in Oregon. As the name suggests, it prohibits women from working more than 10 hours a day. And Kurt Muller, he owned a laundry and he made his female employees work more than a 10-hour day. And so there were protective labor laws protecting women from working 10 hours a day. These ladies worked more than 10 hours a day. He was fined $10, only $10, and he appealed his fine. And it went to the Supreme Court, to answer. And you could see it from Mueller's perspective. He's like, Lochner. And so the question is are state laws limiting women's work week to 10-hour days, is it constitutional? This is a cool case because there was like the Brandeis brief that was submitted. And this was a brief that was submitted to the court that provide scientific and social evidence that harsh working conditions harm women and harm fetuses. And so, in a way, it's sort of like, yay, let's bring science and social science to the courts and let's make decisions based on science, right? There's a good thing with that. But on the flip side of that, that one, that it was, could be seen as sort of seeing women as reproducers, right, and focusing on tough labor and the impact that it has on fetuses. That it's not just enough that these working conditions harm women, but they have an impact on one's reproductive capacity as well. Regardless of where you stand on the Brandeis brief and whether it's good or bad, it was persuasive. And it was, the court concluded that in Muller, that these laws providing protections for women were in fact constitutional. Uh, and why? And it goes with other decisions that the court has made prior to the court cases we read earlier in the semester, prior to the 1960s, where we have a different reading and understanding of the Equal Protection Clause. This was before that. And so they say that women are special and they need protections. And due to impact on women, the state has a strong interest in protecting this category of women. It doesn't overturn Lochner because it's constitutional to treat men and women workers differently. Now, this case would have failed, under our understanding of the Equal Protection Clause today, but this was prior to that, and it shows that these protective labor laws for women were deemed constitutional. So, following Mueller, and getting the green light on protective labor laws, that women are seen as a special labor force in need of protection. And this is the dominant viewpoint, and it's reflected in public policy until the 1960s. Congress establishes an agency for the task. So if the state has a special interest in protecting women, Congress follows suit and they establish an agency for the task of protecting women. And it's called the Women's Bureau, and that it's modeled after the Children's Bureau. Question mark, exclamation point. So, there was a children's bureau that was, basically, we need to protect children. They're a special class, but the Women's Bureau is like, not that they are children, but they also constitute a special class that needs to be protected by the state. It's a good example. This is the it's still in existence, but it has a shift on focus, right? It's housed in the United States Department of Labor, and its focus is more on equity and pay gaps, and also some of the challenges that women might be facing in the workforce. So it's there, but it's not focused on protective labor laws, obviously. Now, just keep in mind that this institutional embodiment of the special workforce view is a reflection of the a policy community coming together, a policy community sort of seeing that women need special protections, and then they work together to create institutions like the Women's Bureau, and then also to create law. And so the Women's Bureau, works with Women's Trade Union League, works with the League of Women Voters, works with the YWCA, works with the AAUW, and they all work together to create policy that is a reflective of their viewpoint that women are in need of these protections. So the social feminist viewpoint prevails until the 1970s. I want you to keep in mind it's not that the egalitarian feminist viewpoint didn't exist. In fact, your textbook you'll read about how egalitarian feminists were really opposed to the Women's Bureau because they were like it's like continuing this uh, perspective that women are different and that they should be separate and they should be treated differently. Keep in mind, egalitarian feminists were like, women or men are the same and they should be treated equally in the eyes of the law. And the egalitarian feminist viewpoint has been around since the turn of the century. Before that, right? The Seneca Falls conference. Um, so the egalitarian viewpoint doesn't fade. It's just not the viewpoint of the day. And the egalitarian feminist viewpoint is just waiting for a new spirit of the times, just waiting for a new zeitgeist, and that zeitgeist comes in the 1960s. And we know the backdrop for the rise of the egalitarian feminist point of view. The egalitarian feminist point of view, second wave um, um, feminist. But there's other things that are going on in terms of diminishing the treating women as a special category of worker. There's a huge economic boom coming out of World War II, and that after World War II, there is a competition between the East and the West, between the United States and the Soviet Union, and so that those are the two superpowers that remain coming out of World War II. And there's a sense that the United States workers need to skill up in order to compete with the Soviet Union on the international front. Not compete in terms of war, but if we're more economically viable than other countries that are sort of like, should we align with the Soviet Union or should we align with the United States? If the Soviet Union is doing better economically than the United States, those countries might be like, we're going to align with the Soviet Union. But if the United States is like, we're more competitive, we're better, then those countries, as they become independent, full in post-colonial, they're more likely to align with the West. That there's the Cold War, the rise of the Soviet Union, Sputnik. They get that satellite up there first, and that the United States is like, shit, we can't fall behind, and so we need to actually up our education for all of our citizens, and also we need to like make sure that we are bringing all workers in or more workers into the workforce. And then there's some social and cultural conditions that change as well. During World War II, women show that they can do the same job as men, even though they lose those jobs after men come back. But it's sort of like, hey, I was there, I did it. It started eroding the sense of women are different and special, that no, they can do the job as well. And then clearly the civil rights movement, the emphasis on quality of character, not on quality of skin, and then also the emphasis, the piggybacking that the feminist movement does with the civil rights movement, that this is about treating all people equally, not just black and white folks, but men and women, gays, lesbian, and trans folks as well. So I will let you read more in the textbook about the equal employment opportunity laws that uh, come forth from this shift in from the special, women should be treated as a special class to women being treated as an equal class. But I just wanted to touch on them before we end out this lecture. But the vast majority of this reading you will be doing on your own, and also looking at more of the contemporary policies as well. But in the Civil Rights Act, we know that Title VII is a part of the Civil Rights Act, and the Title VII basically says that you can't discriminate against people when it comes to work on race, color, religion, national origin, but also sex. Remember, women focused on ending gender discrimination in Title VII of the Civil Rights Act. Also, keep in mind that Title VII, just recently, the word sex has been given a much more expansive definition by the Supreme Court, coming out of the 2020 decision, the Bostock decision, that says that sex discrimination is gender identity and gender sexual orientation as well. But anyways, Title VII, that it ends the era of women as a special labor force, and it brings in the era of equal opportunity. You cannot treat women aren't special, but they are a part of the regular workforce. An individual right of workers to be evaluated on their merits, not on their sex or their race. And you can just see Ruth Bader Ginsburg all over this, right? It's sort of like bringing the treating workers equally and bringing the Equal Protection Clause to say that there shouldn't be this kind of discrimination. That opens the door not just for equality for women, right? But it opens the equality, and it begins eroding stereotypes that we have for men and men workers as well. That men can be nurses, men can work in daycares, men can be work in the hospitality, it can be teachers, et cetera, et cetera. And so that the equal opportunity helps erode stereotypes on both fronts. And not only was there a end to gender discrimination, at least in law, when it comes to employment, but in following up, or actually prior to the Civil Rights Act, is the Equal Pay for Equal Work law that's been on the books since 1963. This, is a step towards that equal employment opportunities, but it's, as we know, it hasn't had as great of an impact as like equal pay for equal work sounds like it would have a huge impact. It ends the long practice of paying women less for the same job. And so if you have the exact same job as a woman has the exact same job as a man, they can't be paid a different salary. It was passed with little controversy. It was supported by male workers, unions. It ends the incentive to hire. It had that support because if you could pay women less for the same job, well, shit, you're going to go with the lady worker, right? And unions didn't like that. Male workers didn't like that. So equal pay for equal work ended the practice of hiring female labor because it was cheaper. It has limited impact, and we know why it has limited impact. It has limited impact because until the Ledbetter Act, that we don't know what other people in your company are being paid unless you work for the state, right? That's not public information. And so you don't know whether you're being paid a different salary until you find out. And sometimes people, you never find out. So it has limited impact for a lot of reasons. It has limited impact because it's not about comparable work. It's about equal work, right? And so if take a restaurant, for example, let's say most of the women work as waitresses, but most of the men work back of the house in the kitchen. Well, those are pretty comparable, right? The restaurant industry, right? Waitressing, working in the back of the house, those are different jobs, but they're comparable work. Well, the Equal Pay Act does not apply to that. It actually has to be equal work, so it's not comparative, and therefore the reach of it is limited. And the pay gap persists, and we'll be talking about that in our discussion. All right, thanks for listening. Talk to you later.